In this class, we'll discuss another important topic, and that is falling under international law. And regarding international law, already we have finished two important topics such as state recognition and state succession, and relating to that already we have uploaded four videos which were exclusive relating to state recognition and state succession. Also another important topic relating to nationality, and in this video we will discuss regarding treaties, the very meaning of treaties and the position of treaties before pre World War and post World War position, and regarding that also treaty making, and as regarding treaty making after World War II, and that is post World War II, and how treaty making was made after the finishing of Second World War, and in relation to that role of International Law Commission and the Vienna Convention on Laws of Treaties 1969, also Convention on Laws of Treaties of International Organization 1986. So we'll go to the very meaning of treaty. So a treaty can be defined as a written agreement by which two or more states of international organizations create or intend to create a relationship between themselves, operating within the sphere of international law. So, from the above definition, we derived four important elements to constitute a valid treaty, and they are: the first one, the agreement should be in writing, and the second one, parties to the agreement should either the states or international organization, and the third element is that the very purpose of the agreement is to create or intend to create relationship among themselves, and such relationship is a legal relationship. And the fourth element, that is the terms and conditions of the agreement should within the scope and sphere of international law. Sometimes treaties are also known in different names such as conventions, agreement, protocols, declarations, accord, contract, instruments, or communique, etc. So, in that connection, we will discuss now the very origin and development of laws relating to treaty making. So, before First World War, there were certain agreements between states like Russia, Austria, Prussia, United Kingdom, and some other European powers in the post Crimea War situation in Europe. But those agreements were on the local and political demands of the then existing local and political needs. Even after the end of First World War, the agreement among the European powers like United Kingdom, France, Italy, Germany, and Russia, etc., were exclusively concluded according to the local demands of the then Europe. So there was lack of uniformity and universality of the application of those terms and conditions reached exclusively between those powers. In the end of World War I, the involvement of United States of America and formation of the League of Nations in 1920 was an attempt to globalize the very nature and scope of treaty making. So it could be said that this was the initial attempt to create a multilateral agreement to operate within the sphere of international law. In the post World War II situation, many attempts were made between United States of America, United Kingdom, Union of Soviet Socialist Republic, France, and some other powers through conferences at Yalta, Tehran, London, Moscow, San Francisco, and Washington for the formation of United Nations Organization in 1945. So the very Charter of United Nations Organization is itself a treaty agreed by a number of states to create a legal relationship among themselves to be operated within the sphere of international law. In spite of that, there was no uniform and universal rules or principles of treaty making. Accordingly, the United Nations constituted the first International Law Commission in 1947. The International Law Commission was entrusted the task of lawmaking, how to form a treaty and what manners and procedure to be followed in the year in 1949. The process of codification of laws and treaty was started by the International Law Commission in several rounds of its meeting, and finally in the year 1966 it was codified and adopted unanimously by the General Assembly in the same year. The General Assembly resolution on laws of treaties finally agreed and approved in the Vienna Convention on Laws of Treaties in 1969. It came into operation in the year 1980. The scope and the sphere of its jurisdiction was confined over the state power, so it was exclusively regulate treaties between two states and among a number of states. Otherwise, it regulated treaty making at bilateral and multilateral level. Another convention was adopted in 1986 on the laws of treaties regarding international organizations. The 1986 convention provided rules and principles governing treaty making between state or states in one hand and the international organization or organizations on the other hand. So now we'll go to discuss the very different kinds of treaties such as bilateral treaties, plurilateral treaties, so also multilateral treaties. So regarding bilateral treaties, so in the traditional sense there were three kinds such as bilateral, plurilateral and multilateral treaties, but the modern laws of treaties of Vienna Convention only recognize bilateral and multilateral treaties. In spite of that, we will discuss about the three different kinds of treaties. The first one is bilateral treaties. These are otherwise called as private law contracts as because mostly signed between two states parties regulating their specific political, social, and economic cultural interests affecting each other. In bilateral treaties and multilateral in bilateral treaties, the municipal laws of the respective state parties plays an important role besides the rules of international law. Due to the role of municipal laws and local necessities, these are called private law contracts. Bilateral treaties mostly cover either conflicting border issues between two states or commercial, scientific exchange, and cultural matters. So, the agreement signed between India and China, India and Pakistan, India and Russia, or between India and United States of America are examples of bilateral treaties. And now we'll discuss regarding plurilateral treaties. So, when agreements are made or reached between more than two states or by a group of states affecting their peculiar local or regional interest or objectives, such treaties are called plurilateral treaties. These kinds of treaties are mostly cover peculiar local political, economic, and cultural interests affecting each other. Plurilateral treaties aim at achieving regional cooperation, mutual friendship, and development by assisting each other at every required level. These treaties are also made to diffuse and minimize political rifts and conflicts between the states at regional level. Such plurilateral treaties are the Organization of American Union and Organization of African Union, European Union, the Arab League, the Organization of Petroleum Exporting Countries and Organization of Arab Petroleum Exporting Countries, NATO North Atlantic Treaty Organization, or SARC South Asian Association of Regional Cooperation, then BRIC, which constitutes Brazil, Russia, India, China, and South Africa, etc., are considered as plurilateral treaties. So, regarding multilateral treaties, we want to examine the very kinds of multilateral treaties. So, any agreement reached among a large number of states, either on political, social, economic, or cultural objectives to satisfy and meet the demands of several states and to achieve international peace or order, or multilateral treaties. Sometimes these treaties are made to diffuse and control international disputes and conflicts. These are law-making treaties, so they perform the functions of international legislation. As considerable number of states are parties to such treaties, so they lay down certain rights and obligations for the states to be observed. and obeyed by the states to achieve world peace and order. And the very examples of such treaties, we could say, the League of Nations of 1920 was of such a multilateral treaty. The Vienna and Geneva Conventions also are examples of multilateral treaties. The Nuclear Proliferation Treaty of 1963, the Comprehensive Test Ban Treaty of 1968, the United Nations Organization and the Amnesty International, etc., would be considered as multilateral treaties, and among these the Amnesty International and some other organizations too formed to check and control terrorism, piracy, hijacking, human rights, etc., are also formed by a number of state parties, and it could come within the meaning of multilateral treaties. These treaties are executed to create general norms of international law. The Vienna Convention on Laws of Treaties 1969 only recognized the bilateral and multilateral treaties as legal, valid, and operative under international law. So, these are the important aspects relating to the very meaning of treaties and the position of treaties before First World War and after First World War, which is we defined as pre and post World War I, and treaty making in relating to that phase, then how after World War II treaty making was made by the United Nations organizations by constituting International Law Commission, and the very task entrusted to International Law Commission is that regarding the very treaty making. So, according to the recommendations of the International Law Commission, the Vienna Convention on Laws of Treaties, and the Convention on Laws of Treaties in relating to international organization in 1986 was enacted. So, this is all regarding the very introductory chapter relating to treaty and treaty making, and in our upcoming video we'll discuss who can be parties to a treaty and the very formation of the treaty. So, what are the basic essential elements required in regards to treaty formation, such as appointment of representatives, and the second stage is negotiation, and the third stage is adoption of the text, and the fourth stage is consent of the state, and the next one is important regarding modes of ratification, and the fifth one, that is regarding how the treaty and when it came into force or entry into force, and the sixth one, that is relating to registration and publication of a treaty after the all the essential formalities fulfilled by the parties in treaty making, and that we'll discuss in our upcoming video.